Welcome to The Free Will Show, a podcast that provides a beginner-friendly introduction to free will while also exploring cutting-edge developments on the topic. I'm Taylor Sear.
And I'm Matt Flummer. In this episode, we talk with Gideon Yaffe about whether and to what extent children should be held less culpable for breaking the law.
Thanks for listening. I'm very happy to introduce Gideon Yaffe, who is Wesley Newcomb Holfeld Professor of Jurisprudence and Professor of Philosophy and Professor of Psychology at Yale University. Longtime listeners of the podcast will have heard his name several seasons ago in some episodes on free will and science, especially in our conversation with Uri Maus about free will and neuroscience. But in addition to his collaboration with scientists, Gideon has research interests in philosophy of law, metaphysics, and the study of intention and the theory of action. He has many articles and books that will be of interest to our listeners. But I'll just mention the book that's going to come up several times in our conversation today, and that's The Age of Culpability, Children and the Nature of Criminal Responsibility, which was published in 2018 by Oxford University Press and is on the topic of today's episode. Welcome to the show, Gideon. Thanks for joining us. Can you start by telling us a bit about yourself, your work, and how you came to be interested in working on issues related to free will, moral responsibility, and the law?
Yeah, sure. Well, thanks for having me. I'm really glad to be here.
Thank you.
And actually, you know what? So you mentioned that I work at Yale, but I'm currently at the Center for Advanced Study of the Behavioral Sciences at Stanford. That's just for the year, which I only mention because I think it's like me actually be like a requirement of my grant to mention that I'm here. So in any event, yeah. But yeah, I'll be back at Yale next year.
Mm-hmm.
Right. So yeah. So let me see. How did I get interested in free will? I got interested in the problem when I was in graduate school, and I ended up. And then I was also interested at the time, very interested in early modern philosophy, and I ran across Locke's long treatment of the free will problem in the essay concerning human understanding.
Mm-hmm.
And I liked Locke a lot. And I thought this chapter was convoluted and crazy and had been revised a bunch of times. And it was like super fascinating. And then when I looked for secondary literature about it, I found almost none at the time. So I thought, wow, this is exciting. Like, where do you find, major work by a major figure that hasn't been written about a lot? So,
Right.
So then that became the topic of my dissertation, was Locke's views on freedom of will. And then basically as I've just gone on and on, I've gotten more and more interested in the problem, and then interested particularly in the applications of the problem to issues in the law.
Mm-hmm.
And that's kind of where my research has been focused for a while now, for like 20 years or something like that.
Yeah.
So,
very cool.
Yeah.
Several of our recent episodes have focused on issues related to criminal punishment. In this and the next couple of episodes, we're looking at a few types of criminal offenders that, for one reason or another, raise special questions about punishment. Our focus today is on children, people under the age of 18, who are typically given a break when convicted of criminal behavior. Can you tell us what you mean when you talk about giving kids a break?
Yeah, so there's just a lot of different forms of leniency that the legal system gives to children. So one of the main the first one, probably the most obvious, is that children are ordinarily not tried for crimes in adult court. They're tried in juvenile court,
Right.
so juvenile court is supposed to be, there's a real question whether it is, but it's supposed to be about the best interests of the child, where adult court is not about the best interest of the offender at all. So this is one form of leniency, is just that first huge thing. And then in addition, when kids are punished, they're punished somewhat differently from the way in which adults are punished. So for instance, one of the main things is that children are not ordinarily sent to adult prisons. They're ordinarily sent to juvenile detention centers, which are, by some measures anyway, much more lenient than adult prisons. Children who are tried as adults, I don't know how much we'll get a chance to talk about the transfer to the adult system, but I'm really appalled by transfer to the adult system. I think that's just an evil thing. But children who are tried as adults, they're often given lesser sentences than otherwise identical adults.
Right.
So, for instance, and this is one important thing, is that they're ineligible for the death penalty under the United States law, and there's also significant limitations to when they can be given life without parole. That has to be made by a specifically made by a judge. It can't be a mandatory life without parole sentence. So it can't be made just automatically by the legislature. It has to be made particularly by a judge judging that the crime, that the kid was not, was incorrigible. So in any event, these are different ways in which the legal system gives kids a break.
That makes sense. In the book that I mentioned earlier, The Age of Culpability, you say that not only are kids rightly given a break under the law, but it's not actually that easy to produce a defensible rationale for giving them a break.
Yeah.
So you consider some common ideas about this, including the thought that giving kids a break is reasonable, given that kids are less blameworthy and so less deserving of punishment than are adults. What's wrong with this rationale, and why is it so difficult to give a defensible rationale of giving kids a break?
Yeah. So in one form, actually, I myself defend in the book the idea that kids are deserving of lesser blame.
Right.
But I think that turns out to be a difficult case to make, mostly because the primary way in which we notice differences in culpability between people is because there's differences in psychological states that led to their action.
Mm-hmm.
So, and then this is handled in lots of different ways in the law. So, for instance, kids who do, or anyone who does something intentionally, causes harm intentionally, is going to be more culpable than somebody who does the same thing, causes the same amount of harm, but negligently. So that as we distinguish between intentional performance and negligent performance, those are different degrees of culpability. So that psychological difference, the psychological state of the person who's careless as opposed to the psychological state of the person who intends harm,
Mm-hmm.
then matters to culpability. And so then the question, so ordinarily anyway, that's the way we do it. We find psychological distinctions, and then those are what ground differences in culpability. But with kids, so why should we be giving kids leniency? Well, is it that they're less culpable? I mean, in fact, you could have a person, as a matter of sort of a thought experiment, you could have a person, two people who are exactly identical psychologically, but differ only in age. And then the question would be whether we were in any way warranted in giving leniency to the younger person.
Right.
And so I think we are. So that's what's very difficult to explain, because you can't appeal to what it is that you ordinarily appeal to explain differences in blameworthiness. You can't appeal to a psychological difference in this thought experiment. I mean, these people are twins psychologically. Mm-hmm. And then in addition, if this isn't just a thought experiment. So it's like, mm-hmm. There's lots and lots of precocious kids. So right. Kids who are, capable of the same forms of self-control as adults. And immature adults. So why should we be distinguishing them in degrees of blameworthiness solely on the basis of age, when the precocious kid might be just as psychologically mature, just as capable of self-control, for instance, as somebody several years older, yet we're going to give that child a break. That child will be tried through the juvenile system, won't be subject to the death penalty, with like a variety of things of this kind. So I think that needs justification. And so that I think is very hard to do in the usual ways in which we distinguish people on the basis of culpability.
Right.
Yeah. Another point that might seem relevant here is that kids are not kids forever.
Yeah, right.
One might argue that when engaging in criminal behavior, kids act from psychological mechanisms that are developmentally appropriate for whatever age they are. Or one might emphasize that criminal behavior in kids is a product of features that they're going to outgrow. You consider these points as potential reasons for giving kids a break, but argue that they are not defensible. Could you explain what your objections to these proposed rationales are?
Yeah, sure. I mean, so I should say, actually, so you raised two different rationales there. So one is that the second one you raised was that it's a temporary condition. Mm-hmm. So they're in a criminogenic condition. They're in a condition that gives rise to crime. And then, but don't worry, in a few years they won't be in that condition.
Right.
That's one line. And then the other line says, oh, well, no, in fact, they're in this condition. It's just that it's totally normal for them to be in this condition. Right? That's just what it is to be a kid, to not care about anybody but yourself, for instance.
Yeah.
So those are different, I think. And I think that and both are, and actually they both get something right, actually, but they're not sufficiently generalizable. So that is, I think there's going to be lots of cases of, so for instance, take the temporary condition situation. There are going to be lots of adult crimes where you have no reason whatsoever to believe that it will be repeated. I mean, they're just, it was a product of circumstance. Why did the person commit the crime? Because they were given the opportunity. When are you going to walk past a panhandler and see that he's asleep and there's $100 bill sitting in his cup? So you take the $100 bill. When is that ever going to happen again, right? It's maybe never going to happen again. But the mere fact that it's never going to happen again doesn't usually give us reason to be lenient. Or if it does give us reason to be lenient, there's limits to how lenient we should be in light of that. And there isn't anything based on age. So the temporariness of it isn't an age thing. That might be frequently true of children, but it's not always true. So it's not generalizable to the full range of ways in which we think kids, or which I think anyway, I think kids are deserving of leniency. So that's one thing. And then another, so on the it's normal for kids to be this way. I mean, I actually don't, so I think there's actually a real question as to whether or not that's true in the most obvious cases. So the most obvious cases involve really, 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 really terrible crimes by kids.
Yeah.
In what sense are those developmentally normal? Like, I mean, they're just, they're abnormal for everybody. So, they don't really seem developmentally normal to me. I mean, the other thing is that even if it is normal, there's often ways in which we want to criminalize behavior that's normal. In fact, that might even be one of the main reasons why we want to criminalize it, because it's like this becomes so widespread that we think, oh, wow, we need to make that a crime. We need to cut down on it and change it. And so you might think also about the normal stuff with kids. So these are incomplete, at best, incomplete explanations for the leniency that we give to kids.
Right. Yeah, that makes sense. Well, your own defense of giving kids a break is different from those proposals we've just been looking at, and you develop it over the course of the majority of your book, The Age of Culpability. So this is admittedly probably a hard question to answer briefly, but could you give us a summary of your own rationale for leniency for giving kids a break?
Yeah, I will try. So the basic thought is that so what is criminal culpability? What is it to be culpable? So I argue in this book, in some ways, actually, I think this is the piece of the book that I'm most proud of, really. But I like the cover a lot, but but
it's a gripping cover. Every time I look at it on my desk, I'm like, oh wow, that book it's staring me down. Yeah.
It's funny about that cover, actually, because I was trying to figure out the cover, what to suggest about the cover, and then I went to the Museum of Modern Art in New York, and I walked by that picture because it was on the wall, and I was like, oh my god, like that's, but
yeah.
So what is criminal culpability? So what I argue in this book, and I've argued something similar in other places in my work, is that when you're criminally culpable, that to be criminally culpable is for there to be a gap between the legal weight of reasons to do particular actions and how much weight you put on those actions, how much weight you put on those reasons. So, for instance, if somebody kills another person, what is it to be criminally culpable for that? Well, the law tells them to put more weight on the other person's life than they put on their interests. So they kill them for money. The law tells them, no, another person's life is much weightier than money, right? So much more weightier that it's like to even weigh the two next to each other is really bad. Mm-hmm. So So they kill another person, they do it for money. What makes it culpable was that they underweighted the other person's life, or they overweighted the money. That is, there's some gap between what the law demands that they weight, the weight that they ought to give to these things, and what weight they do give. And so the culpability consists in that difference in weight. So this is why, for instance, so I think this explains why psychological differences matter so much to culpability. So when you intend to commit harm, you actually give a positive weight to something that the law tells you to give negative weight to. And by contrast, when you harm somebody negligently, you don't give enough weight to it to attract your attention. So you overlook it, but perhaps you weight it just as much. If you had noticed that it was at stake, you would have weighted it just as much as the law tells you ought to. So it's the gap between the strength of legal reasons on the one hand and the weight that you give to them on the other that constitutes culpability. So then what does the weight of a legal reason, what determines that? And what I argue at the kind of ridiculous length in the book is that the weight of a legal reason is in part a function of how much say you have over the law. So the more say you have over the law, the stronger is the legal reason that you're under. And the thing about kids is that they have less say over the law. In particular, they lack the vote. That's one of the most notable ways. And the other way is that they have significant limitations on their freedom of speech. And these are two ways in which they are significantly diminished in their say over the law. So I think that the weight of the legal reasons that apply to them is significantly less. Mm-hmm. And so even psychological duplicates who differ only with respect to the vote can nonetheless differ in culpability, because the gap between what the weight of the reasons that they face and the weight that they give, so they give the same weight to the reasons,
right?
But the reasons that the law places under them are stronger for the person who has say over the law than the person who doesn't. And so they can differ in culpability. So since culpability then matters to blameworthiness, I say it matters to blameworthiness that you're a kid, mm-hmm. even though it doesn't matter necessarily to the psychological states that you're in. That's the main idea. That's right. The kind of the driving idea in the book.
Can I ask a quick follow-up? So it seems like that's an account of how blameworthiness works from the legal point of view, or when it comes to the law. Do you think that that's related to just blameworthiness in the moral sphere, or is that an unrelated, domain?
Yeah. I don't think it's unrelated. So here's my instinct. My instinct is that. And I don't really have like a great argument for this, I'm afraid. I don't really have any argument for this. So that's really not a great one. My thought is that that's something similar goes on with morality. So that is morality. So there's a moral reason, a very strong moral reason for you to, not hurt another person.
Right.
And then you can be culpable and blameworthy for hurting another person. What is your degree of culpability, your degree of moral blameworthiness for that? Is going to be a function of how weighty that reason really is versus how much weight you place on that reason. Mm-hmm. So that's the moral reason case. Now, legal reasons, I think, are a separate thing. So they're not a species of moral reason. Okay. They're not a species of aesthetic reason. They're their own kind of reason. And so there's going to be their own kind of culpability, which I call criminal culpability. But could you have moral culpability? Absolutely. Just as you could also have aesthetic culpability. You could fail to put as much weight on realism as you're required to aesthetically, for instance. So that basically the thought is there's many different kinds of reason. What goes along with all these different kinds of reasons are different kinds of culpability. There's one particular one we care about a lot, which is legal culpability or criminal culpability. And that's a function of the strength of criminal reason or legal reasons.
Mm-hmm. Yeah.
Interesting.
So the first thing that comes to mind when I hear that your degree of culpability is related to your amount of say that you have.
Yeah.
That's the idea. So what about adults who don't have say, like in some states, convicted felons can't vote, and immigration status affects whether or not you can vote.
Yep. So in fact, actually, so So this is actually, so I've actually published a couple op-eds. This is, here I'm supposed to be plugging myself, right? So please look up my op-eds online. So I think felon disenfranchisement is totally wrong.
Mhm.
And one of the main reasons that it's wrong is that felons who then commit crimes, who recidivate, who commit a second crime, while lacking say over the law, are thereby, I think, diminished in culpability for those second crimes. Yet we don't treat them as less culpable. We treat them, if
Right.
anything, as more culpable when they recidivate. And I think that's just a deep injustice. There shouldn't be. So now what's the solution? So one solution would be to give them lesser punishments for recidivist activities, but that's crazy. So what should we do instead? Well, we shouldn't deny them the vote.
Yeah.
We should give them the vote. They should have the say over the law. So I think that they are diminished in culpability if they don't have the say, which I think is just appalling, given that it's not really possible to imagine being more lenient to them in light of that. So that's the way I think of the disenfranchised, the different disenfranchised felons.
Yeah. Mm-hmm.
But so similarly with visitors to this country, whether they're immigrants, whether it's a legally mandated visit or a not legally mandated visit. I mean, so all of these cases, these are people who they do things if they lack say over the law, and they also lack freedom of speech, which is another way of having a say over the law, they are indeed diminished in culpability. Now, what's the right solution to that? It could be that the right solution to that is to treat them more leniently, which in fact in some ways we do during the immigration system. But I have to admit that much of the ways in which these issues arise for immigrants and for asylum seekers, I think it's less well worked out in my thinking than I would like it to be. But you're absolutely right. It does have implications for the view does have implications for how to think about their criminal culpability.
Interesting. Whether it's for reasons you think giving kids a break is justified or for some other reasons, what does it look like to give kids a break? What sort of leniency do we owe children?
Yeah. Well, so one of the main things is that we owe them lesser punishments for the same crimes. That's the main force of the leniency. And what this means so I also think they shouldn't be at risk of punishments comparable to those that we give to adults.
Right.
And so I mentioned earlier juvenile transfer. So this is one of the reasons that I think juvenile transfer is so wrong. So that is, when you transfer many juveniles, except for perhaps those who have committed the most severe crimes, they are going to be subject to exactly the same penalties as adults.
Right.
And so why? I mean, so where in fact I would say they are indeed diminished in culpability, despite the fact that they've done really, really terrible things, just absolutely terrible things, which if they were done by an adult, they would be worthy of a very severe punishment. These children are worthy of lesser punishments than that. So that's one of the main way is through lesser punishments. But and this is, I think, what's wrong with juvenile transfer. But there's other ways in which I think we should be more lenient to children. So, and a lot of them do derive from the way in which kids have less say over the law than adults. So I spend some time in the book on thinking about interrogation. So for instance, should you be allowed to interrogate a child when without a parent in the room? So you can interrogate an adult without a guardian in the room or some other adult in the room.
Right.
Should you be allowed to interrogate a child that way? I think not. So why not? Well, so I try to explain the way in which this might be implied by the explanation that I'm giving for child diminished culpability.
Mm-hmm.
So that's another way in which I think we should be treating children more leniently. So it's not. So I mean, short of the point about juvenile transfer, a lot of what I'm suggesting about ways in which we should be treating children more leniently are ways in which we do, at least officially,
Right.
treat children more leniently.
Yeah.
Right. That makes sense. So, if one accepts your rationale for giving kids a break, we've already asked about this a little bit, but should one think that any other groups of agents are owed the same sort of leniency?
Well, so I think that there are other groups of people who are disenfranchised.
Right.
So so one thing we've already talked about was the felon disenfranchisement case.
Yeah.
Another set is, so when you start to think about whether or not poor people are disenfranchised. So this is actually something I've been very torn about as I've thought about it. But I think that there will be many cases of poor people who are disenfranchised. So that is the way in which I think of having a say over the law is you have an entitlement to exert influence. That's what it is to have a say over the law. Not that you necessarily exercise that entitlement, but you have the entitlement. That what the say over the law consists in is the having of the entitlement. So you can imagine people who suffer from severe forms of poverty or diminished education, where the way in which that they don't have an entitlement, it isn't a real entitlement. That is, in theory, they could walk into a poll, walk to the polls and vote. In theory, they could do that.
Right.
But what they're lacking is the kind of conception of how to make that work, or the conception of how to do that consistent with the million other things on their minds,
Right.
like, working the 5 jobs that make it actually not meaningfully possible for them to exercise that entitlement. So I would say that those are people who lack a real entitlement. And if they lack a real entitlement, then they actually lack say over the law, and so they're diminished in culpability.
Mm-hmm.
So that's the way in which I think about the bearing of something like poverty on criminal culpability.
Yeah.
That is, what you have to assess is the degree to which the condition of poverty or whatever condition it is results in their lacking a real entitlement to have say over the law. And if they do indeed lack a real entitlement over that, then they are diminished in culpability.
Mm-hmm.
So I wouldn't say, for instance, that it follows merely from the fact that somebody is poor that they have diminished say over the law any more than, but where by contrast it does count, it is sufficient to be very young that you lack say over the law. But you can find out in particular cases about many poor people that in fact they do lack a real entitlement over the law to have a say over the law. Mm-hmm. And that's the way in which those particular people would be diminished in culpability.
Yeah, that makes sense.
Is this going to come in degrees? So should we hold rich and powerful people more responsible, more culpable?
Yeah. So what's interesting about the rich and the powerful is that they actually don't have greater entitlement to have a say over the law,
right.
At least, right? So they're entitled to exactly the same say over the law as everybody else. Mm-hmm. But what they have is a lot of power to exercise greater entitlement than they actually have, or greater influence over the law than they actually are entitled to.
Yeah.
So my tendency is to think that the measure of culpability should be entitlement, not actual power.
Yeah. Mm-hmm.
And this then gives us reason to think that we should be holding rich people and poor people, or rich people and less rich people, to exactly the same standards of culpability. But this is another area where I'm less confident about my answers than I would would like to be.
Yeah. So I wanted to ask about a case where, maybe someone has a real entitlement to the vote, and that, they're not in a position where it's like, they can't make it to the polls for one reason or another, but a case where maybe free speech is involved, because you mentioned earlier that might be another way of having or not having a say over the law. Are there any cases where someone has the real entitlement to vote, but I don't know, they deserve a break just because of speech issues?
Oh, that's interesting. I wish I thought about this kind of case more than I have.
No, that's good.
Yeah. No, so what you're imagining is somebody who has a real entitlement to exert influence through the vote, but who lacks a real entitlement to exert influence through speech.
I was just wondering if there are. I don't have any cases in mind. I was just wondering if there were any
Yeah,
such cases, because it's in the kids' case. You mentioned it's a little bit of both, but I wondered if
right.
there were any kind of straight free speech cases. Yeah.
Yeah. So here's what I think. I think we could probably construct examples, but it's not like I have an example to hand
Yeah.
exactly. So that is, we could construct an example of somebody, for instance, who can get to the polls and exert their influence that way, but is incapable of writing. So what they're incapable of is actually expressing any of their ideas.
Mm-hmm.
So what they're not capable of doing is writing to their congressman or standing on a soapbox and telling people what they think. That's not what they're capable of doing.
Mm-hmm.
So what should we say about them? Well, I mean, what's peculiar is that they are in fact entitled to do those things,
Right.
but they can't. So is there a problem there which would make it they don't have a real entitlement? Yeah, it's hard for me to think of it that way.
Right.
So yeah, I don't know. I actually not sure how to think about some of these kinds of free speech versus the vote sort of issues.
Mm-hmm.
Yeah. Well, your book is relatively recent, and by now I'm sure you've received a lot of feedback on the main argument. What are one or two of the most serious objections that you've seen, and how would you respond to them?
Yeah, so let me see. So the most serious objection that I've gotten, honestly, has been people who just bite, as I would see it, they bite the bullet. They just say you're overstating the degree to which children are deserving of a break. So they would say the precocious child, if they're really as precocious as the adult, they're just not deserving of a break. That is, culpability is merely a function of psychology.
Mm-hmm.
And so we should be, and now they then say, well, maybe we have trouble figuring it out that a kid is actually mature enough, but that isn't really about how much punishment they deserve, for instance. It's just so this would be to say, so some of the reasons that I have for thinking, so you're like asking about replies also.
Mm-hmm.
One of the main replies that I have to that argument is to think about gender in this connection. So girls mature faster than boys. This is kind of a well-known fact and documented in lots of psychology. And so by this kind of argument, what this means is that, in fact, girls are going to be more likely to be so mature as to be deserving of the same punishments that adults would be given than boys are.
Mm-hmm.
Yeah.
So if we were to really give up on this idea that age is what matters, and that what matters is just level of psychological maturity, then what we ought to be doing is we ought to expect there to be much harsher punishments for girls than for boys. Now, that seems, I think, to me, that just seems appalling, right? So this is an implication of the view that's been pressed against me here, which I just don't think even the people who press it are going to want to accept.
Mm-hmm.
So this is a kind of ad hominem argument against that kind of line.
Mm-hmm.
So
you have two bullets to bite in that case.
Yeah, well, right, exactly. Yeah, no, that's yes, or it's maybe obviously a bigger bullet or something.
Yeah.
Yeah. So then the other line, which is actually, I mean, I wish I had thought it through really when I wrote the book, but which has sometimes been suggested to me, is that what goes along with age is just opportunity to be good. So that is, the thought is, so what's the difference between the 16-year-old and the 19-year-old who, commit exactly the same crime, and maybe they commit it together? What's the difference? The 16-year-old had a few less years to grow up. So they had less opportunity to develop.
Mm-hmm.
And so that this difference in opportunity, one might think, somehow matters here to the degree of punishment that's deserved. And so I see the appeal of this kind of thought. So initially, when I wrote the book, I think my view was what matters isn't opportunities. I mean, there's going to be, so two people might differ in opportunities and nonetheless are equally bad. And so then why should they be differing in the degree to which they deserve punishment? We need to appeal to something other than an opportunity to grow up. I mean, so for instance, also, like, there's going to be 16-year-olds who are invested with skills that make it possible for them to grow up really fast. And there's going to be 18-year-olds who are lacking such skills, who are going to grow up very slowly. Like, so it seemed like this is a kind of messy way of thinking about issues that I didn't feel like could be developed into a coherent position. But I'm a little less certain about that. So it's possible that you could start thinking about these as like opportunity as loss, as what undermines as what it is which grounds diminished responsibility of kids, or diminished culpability of kids, or generally grounds leniency to kids. Mm-hmm. And I don't know exactly how that would be developed. So nobody has actually tried to develop that kind of view, but that seemed to me to be there's something intuitively attractive about it. It looks like a line of objection that I hadn't really thought through.
Yeah.
Interesting.
Yeah.
If we could ask you one more question, given that our show is called The Free Will Show, could we ask you about age and its connection to free will? Does free will sort of track age, or are these separate issues? What do you think about the connection between those?
Yeah. So I guess I've thought about this really largely through the lens of John Fisher's idea of semi-compatibilism. Mm-hmm. So that is, there's such a thing as freedom of will, which is incompatible with determinism. And then there's that which we sometimes refer to as freedom of will, which is the necessary condition of responsibility,
right,
which is compatible with determinism. And so does age... So I've tried to explain the way in which age matters to the second, right? It matters to the thing which is necessary to responsibility. The reason it matters is because of this stuff about the gap between the weight you put on reasons, et cetera, and the role that having a say over the law matters to that. But I don't think that really has anything to do with the capacity that Fisher describes as incompatible with determinism. So who has the capacity which is incompatible with determinism? I'm not sure anybody has that, honestly, but I don't see how age would tell us anything about the question. So it's possible that people develop it at some point in their lives and they don't have it, and then suddenly they wake up one day and they can act otherwise. I don't know, but it doesn't. It seems to me very unlikely that that's the way of thinking about the relevance of age to responsibility. And it's the bearing of age to responsibility that is kind of like the thing that the law is obsessed with, and the thing that really is relevant to the question of leniency towards children.
Yeah. That makes sense. Mm-hmm. Well, thanks so much for joining us, Gideon. This has been great. Where can listeners go to follow your work?
Well, that's a good question.
That we'll link in the show notes.
Yeah, I mean, I don't know, Google me or something. You'll find that there's only one other person that Googles me, who's me. But so I don't know. So I mean, I don't know. I publish in the philosophy journals. Occasionally, I publish in law reviews. I write some op-eds. I don't know. That's about it. There's no central location that you can go to, I'm afraid.
Yeah.
We'll link some of those things. Yeah, thanks.
I'll link them.
No, thank you guys. I really appreciate you doing this. It was fun.
You're welcome. In our next episode, we'll turn to psychopathy in the law, and our guest will be David Shoemaker, professor of philosophy at Cornell University.